Welcome to the Let's Talk Paralegal podcast, where the legal industry gets real. I'm your host, Eda Rosa, legal consultant, speaker, and founder of Eda Rosa LLC and the Limitless Paralegal Academy. This isn't your stuffy legal studies school lecture. We're talking mindset, money, modern workflows, and how to build a career and a life you don't need a vacation from. Let's cut the fluff, raise the bar, and change the game one conversation at a time. If you like what you hear, feel free to share and send us your feedback. Now let's talk paralegal. In this episode, I get to speak with Gary, an employment law attorney, where he discusses the ins and outs of some main issues with employment law and shares his insights on the future of employment law. Tune in to learn how these critical issues are shaping the workforce and what legal professionals need to know. Listen in for more. Hey everybody, welcome to the Let's Talk Paralegal podcast. Today I have Gary with me. Yes, he's an attorney, but he's a cool one, so don't knock it. Keep listening. No, I'm kidding, guys. You know, we love our lawyers here, and he's doing good things for good people, hardworking people, and that's what we're going to talk about today. So, Gary, without further ado, I know this is the awkward moment where you got to introduce yourself and you're trying to figure out what you want to say, but let's at least dedicate 5 minutes to that awkward moment.
Absolutely. Thanks, Ed. I really appreciate you having me. So I'm Gary Martoccio. I'm a plaintiff side employment attorney. So I represent employees against employers. So representing a wide range of employees, could be anywhere from an hourly part-time worker to a physician or a C-suite level employee. This is all I've done in my legal career. So for almost 13 years, I've been on this side, handling only employment claims, only on the employee side. And yeah, it's definitely interesting. It keeps you on your toes. It's an ever evolving area of law. There's never a shortage of drama and stories in the workplace. So yeah, that's the gist of what I do. And yeah, thanks so much for having me. I really appreciate it.
Now I'm upset that I didn't bring the popcorn because this is going to be a juicy conversation. So if you're listening, hit pause, get your popcorn, let's go for a ride. But obviously, with the new administration and always with the change in our political system, doesn't matter. We're not getting political here. There's always going to be change, right? So regardless of what side of the coin you're on, or even if you're on the coin, because I know a lot of people that are just impasse with this. So there's a lot of emerging trends in the workplace, especially with this new, I don't actually know, maybe you can answer this, if it passed or not, with the DEI and the equal opportunity and all the discussions that are happening right now. I know these are some trends that are out there, but I don't know if they've actually officially have passed or anything. So, what can we do, right? Like when we're in this position, obviously hire a lawyer, duh, Gary, let's do it. But aside from that, how can we be proactive? I'm all about being proactive, not reactive. I'd rather be prepared than not. So let's discuss that a little bit.
Right. With this administration, DEI has been probably the biggest topic as it relates to employee-employer relationships. Now, I will say I don't do anything related to federal government employees. So that's where you've seen, some executive orders, some sweeping changes to change anything related to other employees, from the private sector or even state level, city level employees. To do that there has to be some legislation, which there hasn't been any changes to the existing law. But what we're seeing is the Equal Employment Opportunity Commission, which is known as the EEOC. That's the federal government agency that enforces the employment laws out there. Now, the EEOC doesn't handle federal government stuff. So everybody else that I just said, private level employees and other public entities that are not federal. With a new administration comes a new director. So President Trump appointed a new director of the EEOC. Her name is Andrea Lucas, and she came out of the gates basically saying our objective as an agency will be to basically attack DEI, employers that are using DEI in hiring, promotion, firing decisions, etc. So The EEOC, it'll take some time, but basically, to bring an employment law claim in federal court, you have to file a charge with the EEOC. They have to investigate, and the EEOC chooses what cases they want to enforce and what policies they want to try to change. And the EEOC eventually will take cases into court to try to create case law precedent, and sometimes it'll get all the way up to the Supreme Court down to kind of change the way courts interpret the law. So the biggest thing we've seen is the EEO seems to really want to attack these DEI policies. What they're saying is, look, we have anti-discrimination statutes. It says you can't discriminate based on race, gender, age, religion, et cetera. And they're saying that needs to apply to all races, right? So that doesn't mean you can favor minorities, essentially. You have to be totally, I think they even use the word like colorblind and only merit based, and you can't even use somebody being minority as a tiebreaker in a decision. So I think what the EOC is going to do, they're going to look at charges that they have filed, investigate them, try to get employers to change their policies, and if they don't, then they'll probably try to take, they'll pick a few good cases out here and there and try to take it into a lawsuit and change the case law. That's the topic of this administration. About a decade ago or so, a little over a decade ago, it was during the Obama administration, the EEOC director was trying to change the way the courts interpreted sexual orientation discrimination. One of the laws that governs employment discrimination is called Title VII. That didn't explicitly say that you couldn't discriminate against someone based on sexual orientation. They said sex. And the administration, actually, they were able to eventually successfully, there was a case that went all the way through the Supreme Court during that administration, and they changed the way that Title VII was interpreted, and it now says that sexual orientation discrimination, or at least the highest court of the land, has said that is covered under Title VII. So every administration has their goals, but the fundamental law has not changed. They're just trying to get it interpreted a bit different, if that makes
I
sense.
think
That was
that's
a really long
law.
answer.
No, I know, but I think that's what law is, right? So law is all about interpretation. I think that's why we have disputes in the Supreme Court. Most of them obviously are constitutional rights. I guess the one that everybody should know about is the Roe versus Wade. When they did that, I even had it when I was doing my master's degree last year, we had a whole course on that, like literally a whole class on why it was reversed and, how important the dissents are and all the things. And so it was really interesting to see something that was very personal to me in a different light. And I know sometimes the media loves to highlight everything. Here in Florida, as you may or may not know, we had what called the gay law or whatever, and it had nothing to do with that. Like you literally read it, it was one sentence, and it had nothing to do with what the media and everybody was talking about. And I remember distinctly one of my paralegal friends that was so like destroyed. And I was just like, girl, did you even read it? Like, did you read the bill? Like, it has nothing to do with what the media is talking about. They're highlighting it improperly. And it happens all the time. Always go straight to the source, guys. Just like that was my little soapbox moment for the episode. However, as an employee, I almost said the wrong thing, but as an employee, how can we be proactive in this? I mean, I know that the laws themselves have not, like at their core, have not changed, but like if we do see a potential, discrimination, or we see a big one is sexual harassment, and that also is loosely translated. So understanding that, I guess the remote work has kind of lessened the blow, but still happens. So like how can we be more proactive and more cognizant? Because I remember distinctly when I was working full time at a huge law firm where I had multiple locations, one of the employees didn't even realize it was happening until like later on, they thought it was like a joke or this and that, and then the joke just went too far. But everything, all those actions and language that we used before that, I'm like, no, sweetie, that was all in the same, environment, so sometimes we don't identify these things. So let's kind of educate our audience a little bit. Hey Legal Pros, are you ready to stop playing small? The Limitless Paralegal Academy is officially open, offering powerhouse courses, real world tools, and expert led training to help you build the career and life you actually want. We're not stopping there. The Limitless Paralegal Tour is hitting the road. We're bringing the mindset shifts, career strategies, and community straight to your city with epic speakers, actionable sessions, and zero boring PowerPoints. This isn't your average CLE. This is your legal career reimagined. Join the Academy, meet us on tour, become the legal pro everyone remembers. Visit limitlessparalegals.academy.com to enroll and grab your ticket now. Be bold, be brilliant, but most importantly, be limitless.
Right, right. The biggest thing I would say, if you believe you're being discriminated against or sexually harassed, document it. You want to raise concerns to the employer in writing via email. Make sure you have a copy, either copy your personal email or send it directly from your personal email so you retain a copy. That's a big thing. Now, if you have text messages of discrimination or harassment, save them. Try to get as much documentation as you can because the burden of proof ultimately lies with the employee. And you also want to make sure that the employer is aware because, just because an employee is discriminating against you or harassing you, the employer doesn't technically take on that liability until they become aware. Then the ball's in the employer's court to take action, right? It's called remedial action is what the law says the employer needs to take. So make sure the employer is aware. Save your documentation. Another big topic we have come up is medical related. If you're asking for time off due to medical reasons, make sure you're documenting that in an email or text message and you're following the company's policy for requesting the time off due to medical reasons or requesting the accommodation. I think one big misstep employees have is they aren't forthright about why they're missing time and they maybe are either trying to hide that they're dealing with medical stuff or maybe they think it's better to say that they're not, but I get a lot of cases where the communication on both sides may not be up to par, and that's usually what brings us into a legal dispute. But I would say be upfront, make it clear you're missing time because of medical reasons, or if you need an accommodation, make sure you're saying it's because of medical reasons, and save all your documentation. Obviously, if you're submitting doctor's notes, paperwork related to a request for leave, the FMLA is a big law that covers that type of stuff. Save all your paperwork, and you always want to have a paper trail. A lot of the cases I see, they don't have them. It's a lot of he said, she said, which is what brings us to where we are, right? And, I can't tell you how many times I'm talking to an opposing attorney, and both of us kind of say, I wish communication was better on both sides. My side saying one thing, your side saying another thing. And, yeah, those cases, are ones that usually get resolved, but, it would be better, whatever side has better documentation is going to have the upper hand.
Now, I did mention remote work, right? That is a
Right.
big thing, especially now in the legal industry. After COVID, it kind of really, blew up. We have virtual court now, which I never thought I would see in my lifetime,
Right.
honestly. So thank you, COVID, for something positive. However, having said that, it's reshaped it, right? It's reshaped discrimination and harassment and retaliation and what you were just talking about, accommodation requests. ADA, I know, has a lot of them as well. I learned that in my program. I learned a lot about ADA. I didn't know ADA had ever, like I didn't know how I guess broad it was, like however it's pretty much touched everywhere. So that's another law that you guys should really educate yourselves on, especially if you have an official disability of any kind. But anyways, having said that, like tell me those dynamics, right? Tell us how to navigate through those intricacies because it's
Right.
a little different. It's no longer physical, right? So it's no longer person to person as far as in person, right? So how are you seeing that?
Right. So, honestly, I've seen a lot of the typical discrimination and harassment stuff still happen over Zoom, like we're doing right now. So, those still exist with remote workers, but yeah, you're not getting as much as, I was being, called this name in the break room or the lunchroom, right? Or I was getting followed into the restroom. That type of stuff doesn't happen, but there's still a lot of issues that come from it. A lot of it's related to accommodations and the ADA, like you said. Even though people are working remotely, I think employers have really upped their scrutiny of employees and the way they monitor them, as far as break times, idle time, things like that. So you'll see a lot of situations where someone says, "Hey, I have this medical condition. I need to use the restroom once an hour," or I need a break X amount of times a day. And you get some contested cases where the employer may not think that's reasonable. What we also have seen, a lot of people are asking to work remotely as an accommodation, and a lot of
Mm.
employers are trying to bring people back into the office, not let more people work remotely. And the legal standard is the accommodation reasonable? Can the person perform the essential functions of their job? Does it create an undue hardship on the business? Those are the questions that are typically asked. And think it's hard for a lot of employers to say that someone can't do their job remotely based on what's happened in the past 5 years. And it's also hard to show that it created an undue hardship on the business, because we can pull up the business's financials over the last few years when someone was working remotely. So it's made it more difficult to employers to deny someone's medical request to work remotely. Um, it's created some other interesting topics that this is one that I'm going to keep an eye on as we head over the course of the next few years to see how the court interprets it. And that's with the FMLA. The FMLA allows an individual up to 12 weeks of unpaid medical leave if they have worked for a company for a year or more. There's a certain hour requirement. It's a pretty low amount, 1,250 hours. And they have to be with a company that has 50 employees within a 75-mile radius. That 75-mile radius thing is what is getting contested a lot, because if someone works remotely, let's say companies based out of Miami, Florida, but they have remote workers, all over the
Overseas.
country. Right, exactly. Overseas may be a little trickier. Let's just say everybody's domestic. Um, let let's say the person's from Nashville, Tennessee. Um, that person's obviously more than 75 miles from Miami, and maybe there's no one else that works remotely that's in that person's, state or city, right? The employee side is arguing, my work site, that's what the legal definition, my work site is Miami. That's where I report. There's no brick and mortar work site here in Nashville. My home can't be my work site. I should be counted with everybody else that reports to Miami. And if there's 50 or more employees that either work in person in Miami or report from a remote location in Miami, then I should be FMLA eligible, assuming I meet the other prongs of the requirements. And the employers are saying, "Oh, yeah, it can't be their work site; it's their house, right?" And it really hasn't got fleshed out through the courts yet, and I'm interested to see how it works. There may be a case out there that just happened that I'm not aware of. If someone is out there watching, let me know. But I think that's something that hasn't fleshed its way out, at least in every federal court circuit so far. So that'll be interesting to see how that plays out. But yeah, I think that touches on a lot of the remote
No,
work issues or
I
non-issues.
mean, I think you hit it on the nail, right? I think remote work has definitely changed the dynamics. I know, employers are always looking to nickel and dime everything they can, so we get that. And that's why when we look and discuss, especially FMLA, a lot of people are looking at other, I guess, systems, from other countries that I will not mention, that that's not an issue because they get paid, they worked for it and they get paid. So I remember distinctly when I took my one and only FMLA, which actually was a blessing in disguise. And I'll share this with the audience because I don't think I've ever shared this on the podcast in my 4 years, but I don't think I've had this topic to share. So I guess this is going to be a good one for the audience. So listen up. It was my first, obviously, child, my daughter, and I was working full time at that moment. I had worked with them for 5 years. Again, we had locations everywhere, but it was like a massive law firm. We had over 100 employees. We were the corporate office. So none of that really, affected me. The good thing was that as soon as I got onboarded, since I knew everybody because we had worked prior to another law firm and everybody kind of knew each other, they were really nice enough to provide me with all the current and future benefits, right? And in that package was the FMLA option and a gap insurance, which we all know from the really weird commercials of Affleck. And so I was like, oh, this is really interesting. I can get this insurance and it won't pay everything, but it'll pay most of it. And at least we will have some income coming in because at that point we were very dependent on two incomes. And so obviously we were just getting started. So I was like, I go and I'm really excited about this thing. And I set up a meeting as soon as I was eligible. And at that point, I was like already 3 years in, but I kind of knew that we were in the middle of kind of planning, family planning. So I was like, oh no, I need to do this right away because it says I can't do it while I'm pregnant or if I'm pregnant or whatever. So anyway, as a good paralegal, I read all the things and I met with the Aflac agent a year in advance. And so I met with them and we're sitting there and as I'm talking to this agent, I to this day don't ask me what this agent told me. I have no idea what they said. All I was interested in at that very moment was I can make a business out of this and out of this model because I was like, do they train you to do this? And they're like, yeah, we go through training, we do this, we do that, but we're independent, this and she's telling me all these things. She was super nice. And that's all I remember. And I was like, I'm gonna replicate this system eventually when I open up my own business. And that's exactly what we're doing this year. So kudos to me. But understanding that I have no idea why I did that off the tangent. But what I wanted to go back to was the FMLA issue as far as it goes. It's always been an issue, right? It's always been, on the table. It's always been disputed. It's always been probably the number one cause because it's not as in the general public looks at it as the pregnancy for the female, but there's no like male version of it either. Like, luckily, my husband at the time had a paternity leave. He actually,
Oh,
their
there is.
business,
There is.
yeah.
You should be covered, and we get males that are retaliated against for taking that family leave. Yep.
So I
Yeah.
love it. So, but that's the thing, right? The general public doesn't know that. They just think it's just a
Right.
female, this and that, and it's just a lack of, communication and education, maybe done to street, I don't know. But anyways, aside from that, another thing that I found when I was doing FMLA is that I wasn't gonna get paid, which is why I had that whole conversation with Affleck. And I was like,
Right.
hold up, wait a minute. At this point, I've invested over 5 years with this company. I literally need to take off because
Right.
physically I will not be able to do anything at that
Right.
point. And then fast forward a couple of years later, I was eligible again to use it for something that I honestly it was for my father. He was sick. And so
Right.
they said I was eligible because I was his main caretaker and
Right.
this and that and blah blah blah. But then they denied me because he was hospitalized. And so as soon as, they're in a hospital, pretty much I'm not the caretaker. This is what they were saying. And, like it got a little muggy,
That's
right?
tricky. That
Yeah.
seems sketchy, to be honest.
Yeah.
How long ago
But
was this?
it was long. My dad has long passed. We're
Sorry.
going on his 10th anniversary. But needless to say, I wanted to share these stories with you guys because it's real life, right? This is things that we go through every single day. These are conversations that I like to bring up to the podcast and kind of tie in because regardless of your employment status, these are things that we need to know. We're walking around, law like kind of seeps through everything that we do. So let's just kind of take this with a stride, which actually brings me to the end of this episode, which was a perfect transition, very long one. But we want to talk about the future, right? Of the advocacy of employment law and the wellness and all the things that I just spoke about, right? This is what we want to talk about. So, how can we, create or maybe I guess employees would have to do more policies and guidelines, but I'm curious to know your answer to this.
Yeah. No, that's pregnancy was going to be my big topic that I was talking about for the future. I in the last couple years, I've seen more pregnancy claims than probably the prior 5 or 6 years combined. There's so many issues around that. I think a lot of people don't really understand how the leave works. Employees may think they're entitled to more than they are, but on the other side, employers um, may think that they can kind of get away with everything that they want. I'm seeing is seeing a lot of pregnant women terminated as they're pregnant. Like I used to rarely come across those cases. It'd be like a diamond in the rough that you'd see, but I'm seeing it more and more often. And what I think we're seeing is these employers that have these actual nice policies for their employees to go on leave. I think what we're seeing is the managers aren't the ones that created that policy, and they're frustrated when someone goes on leave. And some employers give 6 months of paid leave beyond what FMLA even allows. FMLA is 12 weeks of unpaid. And what we're seeing is, oh, we don't want her to go out for 6 months and she may never come back. Let's just get rid of her before then, right? So
Mhm.
the better the policy the employer has, the more likely I see someone to get discriminated against because they're pregnant or retaliated against because they're seeking that leave, which is really interesting. So it's going to be interesting to see what employers do with pregnancy related leaves. They all have their own policies. The law of the land, the federal law is only 12 weeks of unpaid, but every employer has some different variation. There's short-term disability that can be paired with disability benefits that can be paired with a pregnancy leave. But yeah, believe it or not, FMLA, you are allowed for up to 1 year, or sorry, up to 1 year from the birth of the child. You can have 12 weeks for bonding. So that even goes for the father as well. And a lot of employers don't um,
I
see
didn't
that
even
or
know
understand
that.
that. Right. So look, I could have a child today. My wife could have a child today. I could wait until March of 2026 and say, hey, I want a month off for baby bonding, and they would have to grant it. Now employers get frustrated and then they retaliate against you. And that's where you want to always document it if you feel that you're being retaliated against. But short answer to your question, yeah, I see pregnancy related issues to be a hot topic. It's really something where obviously, like you said, you work at a place for 5 years, you're bringing a child into this world, and you deserve to have that time off. It's a monumental moment in your life, and you deserve to not have to worry about your job. Now, the flip side, employers are going to be like, okay, what if we give her paid leave and she doesn't come back? And maybe you can create some protection for employers there that says you have to come back and you have to work at least 6 months after that, right? It may be hard to police that or enforce it, but just thinking out loud, how will that shake out over the next decade? I think it'll be interesting to watch. So that's probably the hottest topic. This DEI stuff, I don't know where it's going to go, if anything, as far as changes, but something to watch over the course of the next few years. I honestly think it's a lot of noise at the beginning of the administration. I don't think you're going to see a whole lot change as far as the law. It really puts an employer in an impossible spot if the EEOC is pushing anti-DEI. Um, Okay, but I think that's going to lead to more minorities bringing discrimination claims. So it's a damned if you do, damned if you don't. Oh, now we have, you know, the old white guy can bring a claim. Like if we're favoring them now, and then it's just gonna be. I think it's creating unintended consequences for employers, and I mean, I don't think it's going to be something that is followed through with to the extent that people may think, because it just seems to be one of those like buzzwords that gets people fired up on both sides of the equation. And I don't know if it's going to go very far other than just riling people up like a lot of
I'm
political
completely
stuff.
in
But
agreement with you on that because I always feel like every year the media, the politics, whoever, creates this frenzy. And, for us in Florida, we're always attacked, right? Florida and California, we're always on the news. Something weird is always happening. We always have to be like the pretty little gold shining, star. And unfortunately, we're pretty much, I always call it, the state of Florida is always like a test dummy. Like they always tested on us because originally, if we look at Florida's history in general, we were a retirement state. We were not made, our laws are so old that they were not made for families, right? So updating them obviously takes forever. So, we're really behind on our case law, even though we have so much of it. But I want to tell you guys a little funny story before we wrap up and before Gary gives us his tips and resources to end the episode. I was speaking with this, he's a lawyer, he's from Africa, and actually Tanzania. Let's be politically correct. And he was telling me, he reached out to me because I'm part of the International Bar Association. And he's, just wanting to, he was curious as to what I do because he doesn't understand the concept of not being a lawyer, but still owning a business and still providing services. Like he was just not getting that concept. So, anyways, he reaches out to me out of curiosity. And I was like, oh, this is really cool. This is intriguing. Let me, kind of, pick his brain too. And then he's like, yeah, we're an lawyer law firm that handles trillions of dollars because what they do is they work on transactions, corporate businesses that are trying to look into investing in like nickel and minerals and things that Africa is so richly blessed with. Um, so he owns a law firm, or he's part of a law firm that only has 8 lawyers. That's it. There's no call center, there's no paralegals, and they're doing these multi-billion-dollar transactions, right? And so he was intrigued as to why we have so much litigation in the States and why all these lawyers have all these helpers and this and that. And they're like, when we just, we just do it, And I started cracking up and I was like, perspective, right? And I was like, well, first of all, this law, even though it's very intricate, I understand that it's very transactional, right? Where you're not dealing with people, you're dealing with paper at that point. And so it's a very different when you add the human element. But anyways, I thought that was a funny story because you were talking
All
about the laws and the future. But
right.
Gary, can you give us some like tips or maybe a resource where our audience can kind of, well, other than obviously looking at the FMLA and the ADA and obviously educate yourself and all that, but anything else that you can offer to the audience that may help them in navigating, these pivotal moments?
Right. I think it goes back to one of the first things I said, document everything, retain all your emails. Um, I would say one thing, don't think HR is your friend. HR is typically there to protect the employer, right? And the HR representative may be very nice and great people, but their main job is to protect the employer. So always approach it with a business relationship. HR always wants to talk on the phone too. They keep things out of writing for a reason. And I wouldn't decline a call with a human resource representative if it's related to whatever medical reasons, pregnancy reasons, discrimination claims, sexual harassment. It's fine, go on the call, but I would always follow up with an email documenting the conversation. So you always want to keep a trail of that. Always keep your guard up when dealing with HR. They're not saying they're not good people, not saying they're not great at what they do, but they're there for the company. You got to remember that. So document everything with them. Don't think that they're there to protect you. And I think that's one big misconception that I see employees have and a misstep, honestly. But yeah, those are the biggest things. I think we touched on kind of all the tips. You know, uh, there's a ton of information out there online. Um, Lawyers, especially employment lawyers, tend to have a ton of blogs on their website. So any topic that or question that you have, type it into the Google machine and see if there's an article touching on it, and if it's something where you believe your rights were violated, you should contact an attorney right away. And yeah, there's a lot of good employment law firms out there. I'm in 9 different states, but you know there's great employment lawyers everywhere. So if you have a case, yeah, I'm confident that you'll find someone to assist you. And don't be afraid to contact multiple attorneys, because just because one attorney won't help you doesn't mean that someone else doesn't see something there, or maybe someone has a certain caseload that they have to stay under and aren't accepting any cases. So don't be discouraged. It may take some time to find the right fit. Um, but yeah, there's a ton of resources online. That's the beautiful thing. I wouldn't use Chat GPT just yet. There's a lot of people are using that for legal stuff. Well, it can be a good resource for like editing documents or maybe getting like templates. I wouldn't use it to rely on for like the actual right and wrong of the law. I know lawyers have gotten in trouble for using that for research and stuff. So I'd probably stay away from that for now while that's still working its way through its I guess test stages. But yeah, that's the best advice I could give. And yeah, any other questions? Let me know. It's been awesome though. Really, thank you for having me.
Of course. Thank you so much, Gary. And I love those tips and resources that you provided. And as always, you guys, we leave their contact information on the description box. So feel free to reach out to Gary if you do have any issues, or I always say a friend of a friend of a friend, whatever it is. It's always nice to grow your network regardless. It's always nice to have that in your, surprise box or emergency kit. So thank you so much. And that's it for today. Until justice is served, guys. I'll see you next time.
Thanks,
Bye.
Eda. Bye bye.
Bye.